Forward to it coming back to the House. Thank you.
Mr. Speaker.
Honourable Phil Goff.
Speaker, in her Cabinet paper taking this proposed piece of legislation for approval through the Cabinet process, the Minister describes the bill as making the biggest changes to the family justice system since the Family Court was established in 1981. So we're talking about a huge change. And because of the scale of the change, the opposition would want some assurance that this was a well thought out piece of legislation, it was properly researched, it was based on adequate data, it had been the result of full consultation and hopefully some consensus, and that the process had been trialled. On each one of those counts, Mr. Speaker, from what I've read about this bill, the National Government has once again fallen down in a piece of legislation that it's brought before the House. I base that not as a political statement, a party political statement, but on simply reading the regulatory impact statement and what it says about the background of this bill, why we've got it and the processes that it went through. I base it on recent past experience. And the Minister who introduced this bill also introduced a new system for taking cases through the Family Court in Auckland. And it's been an absolute shambles, Mr. Speaker, because they didn't get it right. Even the Minister has admitted that it's a shambles. The Minister, the Principal Court Judge, the lawyers involved in it, everybody. And I'll come back to that. And thirdly, Mr. Speaker, it's based on the fact that the government set up an expert reference group on family court reform. Now think about those words, expert reference group on family court reform. You would think, Mr. Speaker, that group would have been at the heart of this reform. But what do we find out? We find out that group was not consulted on the key proposals in this legislation, Minister. Not consulted, despite the wrongful claims of the Ministry of Justice. On all of those grounds, Mr. Speaker, there are real causes for concern that the government once again have got it wrong in a piece of legislation they've brought before the House. Look, if you took it on simply what the objectives were of this bill, you'd say there's some merits to it, as long as the mechanism for delivering it was well thought out and equitable. The purpose, to ensure a modern, accessible family justice system that is responsive to children and vulnerable people and is efficient and effective. Who could be against that? Nobody could be against that, except that it's wrong. It doesn't make it more accessible to the vulnerable, it makes it less accessible. How can you make something more accessible to the vulnerable when you first of all put a charge of $1,000 on going there when it used to be free? And how can you make it more accessible and more understandable when you deny people that are having trouble understanding the process access to their legal advisors? It falls down on all of those grounds, Mr. Speaker. Let's look at what the regulatory impact statement says. Well, in its opening paragraph, it lets the cat out of the bag. This is not about reform of the justice system. It starts off by saying, given the overall fiscal situation, urgent steps must be taken to lower the cost of the current justice system. That's what it's about, Mr. Speaker. It's about cost cutting. At least the regulatory impact statement is honest about it, even if the Minister and the Speakers on the National Party side have not been. And then, what is the next paragraph headed? This is astounding, Mr. Speaker. Gaps and uncertainties in policy analysis. The government's own regulatory impact statement talks about the serious gaps and the lack of policy analysis behind this bill, which the Minister says is the biggest thing in 30 years. It says there's been limited research on New Zealand families and their involvement in the family justice system. That's not my accusation, that's the government's own admission. It says that there's been insufficient historical, fiscal and statistical data to accurately predict the average cost of performing some of the tasks associated with the family court processes. And then it goes on, there was insufficient time for piloting proposed processes or for undertaking a proper look at court documents to form the data basis for a new system. Here is the government admitting the biggest change in 30 years has not been subject to adequate research, has not got adequate data, and has not been piloted. What has this government learned from its botch-up in reorganising the court system in Auckland? It has learnt, Mr Speaker, absolutely nothing. And finally, from the regulatory impact statement, have a look at this statement. Because of the time frame, there has been limited opportunity to discuss the final proposals with stakeholders. They haven't done the research, they haven't got the data, they haven't piloted it, and they haven't talked about it to stakeholders. This government, Mr Speaker, is an incompetent government that is rushing in legislation that on its own admission is ill-prepared and will not do the job that it's designed to set out to do, other than one factor, and that is to cut costs. Mr Speaker, first and foremost and last, this is about cost cutting. It is not going to deliver. Now let me come back to the government's advisory group, the expert reference group on the family court. Top judges, top family court lawyers. The Ministry of Justice claimed that this group approved of the proposals that the national government has brought in. The chair of that committee says that that is wrong. That is not true. That is inaccurate. Actually, Mr Speaker, he could have said that was a lie. He says, we were not consulted, quote unquote, we were not consulted on 4 key proposals in our discussions with the ministry, which, if implemented, will potentially place adults and children at risk. This is the expert reference group on the family court established by the government itself, saying not only were they not consulted, but this puts vulnerable people at risk. What is it about that the National Party members speaking on this bill don't understand? It says, and it goes on to talk about the parties having a user pay system, they're going to have to fully fund this. $1,000. What does that do to access to justice? Maybe they'll help a few people right at the bottom, but the people that are lower middle income, that are really struggling, that are finding difficulties, all the things associated with a family breakdown, how are they going to afford the $1,000? And why is it that we put a cost on access to justice when access to justice should be guaranteed as a birthright to New Zealanders? It is wrong in principle. The expert reference group goes on to say that parties and children won't have the automatic right of access to a lawyer. What does this mean? Mr Mann says this means that parents will be intimidated into agreeing to settlements which disadvantage them or their children. Which disadvantage them or their children. What is it about that the National Party doesn't understand? And is this going to save money? No, Mr Mann says this is going to cost money, because there'll be inevitably delays in the court process, because the court will not have the information they need to go on to make a properly informed decision. That will result in prolonged cases, greater conflict between the parties. Now, I want to come to my last point, Mr Speaker, and that is, if you don't believe all of the things that the people, the experts have been saying about this as to why it won't work, let's look at the government's most recent experiment with the family court. It's in Auckland, and it was a new system for processing family court cases. Well, what does Patrick Keneally say about this? One of the most experienced family lawyers in Auckland. He says the wheels have fallen off the family court since the system was introduced in February of this year as part of widespread changes aimed at making the district courts more efficient and more cost effective. Does that sound familiar? The same claim they're making for this legislation they made for the last system change they tried to introduce just this year. The lawyers have said the new system is an absolute shambles. Affidavits gone missing, judges not being given complete files, delays up to several months for hearing dates, sealed orders not being sent, emails and voice messages going unanswered. Like other areas of government reorganisation, this has been a total shambles. Peter Bosher has said that something that used to take 14 days, a serious custody case involving family violence, is now taking 2 months. Is that the government's reform? It used to take 2 weeks, now it's taking 2 months. It's a serious custody dispute involving family violence. Did it save money? No. The cost blowout, Mr Speaker, has been $1 million far more than the savings the system was supposed to deliver. Mr Speaker, all of the evidence here is this is a half-baked idea with half-baked plans to implement it. It won't succeed. They should go back to the drawing board.
I call Materia Toure.
Thank you very much, Mr Speaker. While it's good to have